Hello, I'm Wendy Million. I preside over Tucson City Court's Criminal Domestic Violence Court. We've been in existence for 13 years. We have been chosen as an Office of Violence Against Women mentor court 2 times. We're presently a mentor court. And I wanted to talk to you about our court and how we focus on family safety, lasting change, and what makes domestic violence courts unique. Let me share my screen. So our focus, as I said, in criminal domestic violence courts is family safety and lasting change for our offenders, not just compliance. To me, a criminal domestic violence court has policies and procedures that are unique to domestic violence cases. Other treatment courts, like drug courts, mental health courts, and veteran courts, are focused primarily on the offender. Domestic violence courts focus on the victim and the offender, which is what makes them different from other treatment court models. I'll talk to you today about how Tucson City Court implements these procedures to improve access to services for domestic violence victims, access to justice for both parties, due process for the offenders, and all of it is to reach the goals of continuing family safety and lasting change. So when you think about specialty courts, they come in many forms. Some judges just have compliance dockets, which are post-conviction. There's review hearings with the judicial officer. They're requiring proof of compliance with whatever sentence was imposed, drug testing, classes, things like that. Many treatment courts are predisposition of cases. The cases are funneled in there early in the process. They identify participants. There's drug, alcohol testing, judicial reviews, and a rewards for compliance, recognizing of sobriety benchmarks, and sometimes even dismissal of the charges. Domestic violence courts have some similarities to these treatment courts, but some really specific and important differences in my mind. Similarities, we identify our participants early on in domestic violence court. My court is a serious intimate partner domestic violence court, so our prosecutors work to identify who will be in that court. We have partnerships with our treatment providers for when we have offenders who are convicted non-probation. Just like a treatment court, it's important that we have partnerships with treatment providers. I do review hearings with all of my probationers, so that's a same similarity to a lot of other treatment courts. We work on things besides just making sure they go to their DV classes. We work on sobriety, mental health, and stability. And like these other treatment courts, the defense bar is particularly important to us in these kinds of courts. So, differences. Some crucial differences in a domestic violence court, at least in mine, are that it is not voluntary. The offender does not get to choose whether or not they're in domestic violence court. We focus on the victim, the survivor, as much as we do on the offender in this court. Victim advocate partners are crucial to the success of a DV court. If possible, if you have independent advocates, community-based, that makes it easier, but many courts use advocates that are part of the system. It's an adversarial process, so that's a lot different than many treatment courts. We're on a trial track as these offenders go forward, but we still have a team that's dedicated to making sure we're all following the same policies and procedures without sacrificing anyone's rights or due process. And in my courtroom, there's no reward system or graduation for someone who has reached the point where they've completed classes and hopefully stopped causing harm. So why is voluntary participation a challenging choice? And we've decided not to make that choice. Domestic violence offenders are often working within a structure of what they've been raised, how it's worked for them, how it's worked for their family. And they don't think there's anything wrong with what they're doing because it's worked for them so far. They're very good at shifting the blame. They're very good at minimizing their behavior. And so many of them are not going to volunteer for a program that might be hard for them or require them to talk about what they've done or take accountability at this point in their careers. There's no incentive for the defense bar to encourage participation in a true domestic violence court. We don't offer this as a diversion process. We offer it as a track. You're on a domestic violence court track. It's also really hard to measure success. You can't breath test for abusive behavior at home. So we don't know that the people who are in the courtroom are necessarily abstaining from bad behavior while the case is pending. It's really important to identify participants' predisposition. If you're running a domestic violence court, the way that we do this is, like I said, our prosecutors identify cases. Some of the criteria for staying in my DV court is things like prior convictions, many prior arrests, risk factors like strangulation, guns, stalking, many things that could be felonies, but for whatever reasons are not prosecuted as felonies. Those all end up in my courtroom. The presence of advocates in the courtroom at every stage of the game is really important at these predisposition hearings. If we can connect that victim to an advocate early on, then there's more likelihood that the survivor will keep coming back to court and participate. Not necessarily to testify at the end of the day. That's not our goal. Our goal is to have those victims feel like they have a voice in the courtroom, feel like they could come at any time, and also have options with the advocates. Having them while this case is predisposition also allows us to impose some kind of conditions of release, like drug testing, put somebody on GPS to keep them away, no contact if that's what the victim wants. Equally important is that having these people in your courtroom from the very beginning allows you as a judge to establish relationships with both of them. When I speak to the survivors, a lot of times they didn't want to talk to the advocates right away, or maybe they were being discouraged. I always thank them. I always tell them I'd love to know how they're doing, so feel free to come back to court, and that the advocates can keep them up to date. So I acknowledge that they're there, and I welcome them to the courtroom. The defendants, I talk to them too. And the defendants see that I treat their lawyers with equal respect and that I am very conscious of their constitutional rights as the case goes forward. I don't make any presumptions. I don't act like they're guilty. I have a relationship with everyone. And I think that that relationship is what helps with procedural justice, and it helps with compliance at the end of the day. So a different thing about a DV court than a treatment court is that we focus on victim safety, and it informs every decision that we all make. So obviously the defense attorneys are going to focus on their client and focus on presenting their client's case, but they still also recognize that when the advocates are there and the victim's there, they're the ones who say, Judge, the victim's here. We'd like them to talk to the advocate before we go on. They recognize that that's how this courtroom works, that a lot of times that works in their defendant's favor, and it works in the victim's favor to be able to connect with this advocate, still want the defendant to come home, keep everybody employed, keep everyone in a house. And so that focus on victim safety and the way we develop our policies does not impact a defendant's constitutional rights. What it impacts is the way we run our courtroom and the respect that everyone shows for the parties in the courtroom. We really emphasize victim autonomy. It's a very rare case where I will go against a victim order no contact if the victim wants contact. What we've all learned from our advocates is that sometimes it's safer for a victim to have contact because they may be losing their home. They may be losing the only income earner. They may be losing someone who can take care of the children so they can work. So safety comes in many forms, and we focus on the many forms that safety can come in. Also, having those advocates in the courtroom is really useful when female offenders are charged, because often, as we know, they are victims of domestic violence, and the public defenders will use those advocates to talk to their clients and get them connected to. We know that in a domestic violence court, in a criminal court where we're not offering diversion, adversarial system is inevitable. People are entitled to due process. DV convictions have serious consequences. The system's worked for the offender in the past, so he's going to want to try and have it work again. And it does. We set cases for trial, and many times the victim makes a choice and doesn't come to court. We don't punish those victims. What we are doing is focusing on what we've done before that trial date, and that is having that survivor connected to services. Having everybody in the courtroom trained in the dynamics of domestic violence also helps us in developing policies. It helps, like I said, in treating everybody in the courtroom respectfully, including the victims. We train all of our attorneys, we train our court staff, we train our probation officers, we've trained interpreters. Everything helps us focus on family safety. So I think this is something that is very different than you would experience in other kind of treatment courts. And it's something to keep in mind as a judge when you are doing these kind of review hearings or having this kind of courtroom. So many of the families stay together and the victims want the partners to get help. But at the same time, they're still experiencing violence while the partner is going through treatment. The victims are relying on us, the court, to improve the situation with our mandates and reviews. And the offenders often really want to succeed, but they don't know how. Or often the offenders have no interest in change. So all of these things are happening. And as a judge, as an attorney, you have to keep your ears and eyes open all the time, because risks can also be changing every day in domestic violence court. And things that we say and things that we do can inadvertently increase those risks. Also, victims who have separated are watching how they're treated compared to how their partners are treated. Meaningful review hearings are critical. One, because you want to make sure that everybody thinks that you're credible. Everyone trusts you. So you have to have good information to have a good review hearing. Quality of information matters. Our advocates listen in to all of our review hearings. Often they can't tell us anything. The victims don't want them to tell us anything, but they learn things that they can tell the victims, and that the victims can be kept safer that way. Your treatment providers need to be held accountable to the court too. They need to give you the correct information, the number of classes, when offenders stop going to classes. Those are the kind of things that can make your review hearings meaningful and make sure the things that you're saying are accurate and true. We also address other needs of offenders. Like I said, this is part of that treatment model that I think that we've learned from in DV court. You can't focus on DV treatment when you're homeless, when you have severe substance abuse issues, when you're having mental health issues, when you don't have a job. So we focus on those things, and then we put people in DV treatment because I want them to be stable. And one of the reasons I want them to be stable is for their own good, but also these are risk factors in DV cases that increase risk for survivors. So by focusing on these other needs, we're not only helping the offenders, we're also making sure that the risk is decreased for the survivors in these cases. As I was talking about offender treatment, you need good treatment agencies that are accountable. They should be using evidence-based treatment curriculums, not anger management. They should provide meaningful and timely reports to the court. They should have a relationship with your advocacy agency so they can refer for victims if there's something that's high risk that's going on. They should be available for staffing. My treatment providers, the facilitators will reach out to me and say, Judge, can we talk about this guy? We have staffings, the advocates are there, sometimes the attorneys are there, sometimes probation officers are there, and we figure out, okay, what's going to make this guy successful? What's going to lower the risk in this case? So those are the kind of things. This is the report that we use, and it gives me a lot of information, the comments to talk about the offenders at the treatment, at the review hearings. Having just a number of classes doesn't mean that that offender is participating and learning. It just means that that defendant showed up, and that does not guarantee change. So think about what is your message that you are trying to convey as a judge in these review hearings. And always keep this in the back of your mind. I always have this in the back of my mind, and it keeps me more metered in the things that I might say. There's no way to know if the offender has stopped their behavior at home. Some of these offenders have gone through these classes multiple times. They are very good at just saying the language. Oh, I'm being accountable. Oh, I'm remorseful. You don't know 100% if they're actually changing or if they've learned how to scam all of us. You can't test for success. It's not like staying sober. You don't know if the victim has just chosen not to participate anymore because nothing is changing. And think about if you reward them for completing classes without the abuse having stopped, what message are you sending to that victim? Why would she ever call again? Why would she ever come to court again if her abuser is getting rewarded for compliance in a situation that involved direct harm to that survivor? So in my courtroom, the way we handle people doing well is we talk about their success. I'll read some of the things that is in their final report where they seem to have really taken accountability and responsibility. They're a leader in the group. I have them talk about what they learned, and they talk about how successful their life is now, how this has helped them not only in their relationships, but in their work relationships and their other family relationships. And other people in the room are listening, and that's powerful. And they're very proud of themselves. I don't personally give any other kind of incentives except waiving some of the fines. If they've done a good job, I try and waive what I can waive as a fine, and we save those fines till the end as an incentive. If a judge wanted to give incentives without sending any kind of harmful messages, I suggest something like letting them earn gift cards to a grocery store where they can feed their family, letting them earn gift cards to provide diapers for their new baby. And I can tell you, after doing this for 12 years, these men who do this and have changed are very proud of themselves. And I think they'd be proud and excited about earning that kind of incentive, something that they can show that they're now taking care of their family in a non-harmful way. So it's not my way or the highway. This is just one model of a DV court. It took us 12 years to get to this point where we have these relationships, where we have these treatment providers that work with me on a daily basis. You can start with a compliance calendar. You can focus on DV and treatment, but some of the things that are very important for a successful DV criminal court are advocates and victim input, because you only hear half the story, not even half the story, if you don't have that other half of the relationship available to you. Review hearing efficacy is based on quality of information received. Pay attention to your messaging. The survivor is watching. Don't reward offenders for stopping being violent. Focus on true change and not compliance. And remember, sometimes the only safe thing that we can do is put the offender in jail to give the survivor and the family some breathing space to make decisions. A lot of people ask me, how do you measure success in a domestic violence court? In a lot of treatment courts, you say, oh, by recidivism. Domestic violence is a different breed. Um, you don't know what's happening again in that relationship. You don't know if this has happened again, it's happening while we're seeing, and the victim's just choosing not to engage the system. It's too dangerous for them to engage the system. The system's not working for them, so they're not going to call again. Sometimes we can only keep a victim safe for the probation period where we have direct hands-on with that offender. So we measure in different ways. We measure victim access to services. How many victims have been connected or at least talked to an advocate when they've come to court? And that's a lot. We have so many victims that are able to talk to our victim services agency and our advocates. You can measure by offender change, but it has to be their decision. We can't just count whether they completed the classes. Are they staying sober? Are they getting mental health treatment? And sometimes we tell them, you need to go back. This is change you need to work on for the rest of your life. And none of us can measure if that change is really keeping, sticking with them for the rest of their lives. So these are just some of the things that I think make a domestic violence court more unique and more different. And some of the things you can consider when you're determining whether to start a domestic violence court calendar. Please feel free to reach out to me, to my DV court coordinator, Amanda, or to my mentor court coordinator, Lisa Akers, and we'd be happy to talk to you about any issues you have and share any of our procedures, our forms, anything that we can do to help with this process. Thanks for your time.